Okay, therefore we will start dealing with these type of actions one by one. The first is an action for infringement. The actions for infringement is provided under Article 258, 259, 260 of the Treaty on the Functioning of the European Union. Article 258 provides for the possibility of the European Commission to take a member state before the Court of Justice. 259 provides for the possibility of a member state bringing another member state before the Court of Justice. Article 260 provides for the effect of the judgment of the court. What do you remember about actions for annulment? Actions for infringement. Yes, Deniz?
For example, when there is a serious risk of, the violence of union law, the Commission can see this risk and can see this danger, so it can decide to take an action against member states.
Is there an infringement here?
For example, there are several principles in Euro, and which are very important to develop the legitimacy of EU law and democracy in the EU law. And if the member states do not abide by these laws, for example, there can be infringements.
But there must be an infringement.
Yes.
There must be a breach. Okay, let me explain you. But in very simple terms, what is an action for infringement? What do you remember about that? An action for infringement? Yes, Umut?
A member is failing to act in accordance of the treaties of the European Union.
A member meaning?
Member state.
A member state. A member state may fail to act according to the treaties, or it may act in conflict, being in conflict with the treaties. Therefore, one party to this action, the defendant, is always a member state. The plaintiff, the claimant, may change. Sometimes, in most of the cases, it is the European Commission, and in certain cases, it is another member state. Therefore, according to Article 58, if the European Commission considers that a member state has failed to fulfill an obligation arising from the treaties, it may start the pre-litigation stage or the pre-litigation phase. In other words, the first stage in the actions for infringement is the pre-litigation stage or the pre-litigation phase or administrative stage. In Turkish, idari aşama. When the European Commission determines an infringement by a member state of its obligations arising from the founding treaties, it may start the pre-litigation stage. The aim of this stage is to give the opportunity to the member state to comply, in Turkish, uymak, or to defend itself. At this stage, the European Commission contacts that member state first on an informal basis, and it raises the matter. If it is not satisfied, then it may decide to send that member state a letter of formal notice. The letter of formal notice provides for the summary of complaints against that member state and gives that member state the opportunity to defend itself. If the member state cannot comply, or if the parties cannot reach a settlement, then the Commission may send a reasoned opinion. In Turkish, gerekçeli görüş. The reasoned opinion includes a detailed statement of the complaints against that member state. Sorry? A detailed statement of complaints about that member state, and that the member state must comply. If the member state does not comply, then the European Commission may take that member state before the Court of Justice. If the European Commission takes that member state before the court, then starts the second stage of the actions for infringement, which is called the litigation stage or judicial stage or judicial phase. These actions are also known as enforcement actions. You may find in the book, okay? Actions against the member states. Do you know the difference between, in a legal document, between may and shall? When I say the European Commission may take a member state before the court, is it different than the sentence when I say the European Commission shall take a member state before the court? Yes, Umut?
When you say may, it means that it is capable of.
Capability, may, in law? Sorry? No? We have one very good word for that. Sorry?
Can?
No. No? But you understand when Umut explained. When we say the European Commission may take a member state before the court, is there an obligation?
No.
No. So there is discretion. There is discretion. In Turkish, discretion, takdir yetkisi. The European Commission has the discretion to take a member state before the court, meaning, yes, it may take or it may not take. It is up to the European Commission to take a member state before the Court of Justice. When I say the Commission shall take a member state before the court,
Obliged.
yes, the Commission will take that member state before the court. There is no discretion on the part of the European Commission. So in the actions for infringement, if the member state does not comply with the reasoned opinion of the European Commission, stating that there is a breach and that it must comply, the Commission may take that member state before the Court of Justice. The judicial stage, therefore, starts as a second stage of the actions for infringement. It does not start right away. We did not say that the European Commission will take a member state before the court right away, right after it determined infringement. You understand? There is one phase, one stage before it takes the Commission, it takes the member state before the court. All right? In the litigation stage, the substance of the action is about an obligation under the treaties, meaning that the article of the founding treaty provides that there must be an infringement of an obligation of a member state under the treaties. Therefore, for this action, there must be an infringement of an obligation. In Turkish, üye devletler için düzenlenen yükümlülüklerden birinin ihlali. What would that mean? An obligation under the treaties. This is interpreted as a very general term. It includes infringement of the treaties, the protocols, the secondary written EU legislation, including regulations, directives and decisions. In Turkish, regulations, directives, decisions. Tüzük, yönerge veya direktif ve karar. Infringement of general principles of EU law. Infringement of general principles of EU law. Infringement of the case law of the Court of Justice of the EU. Infringement of the case law of the Court of Justice of the EU. Infringement of international agreements to which the EU is a party. Therefore, the member state concerned may have infringed these sources of European Union law. These are all included under the obligations of the treaties, under the said provision. All right? This infringement may take place in two different ways. Can you imagine how? How can a member state infringe EU law? We have mentioned it at the beginning, though. Do you remember? How can a member state infringe EU law? It may fail to act, meaning? Yes, so in English, by not acting. The treaties may have provided. Don't write, please, now. The member state, the founding treaty may have provided that the member state must have acted in a certain way, and it may not act, or
act in conflict.
Yes, it may act, and this action may be in conflict with EU law. Therefore, it may take in two forms. First, by acting in a certain way. Infringement of provisions because of a certain type of action. For instance, adopting national legislation which is contrary to EU law. We will be speaking about directives in EU law. Directive or yönerge. For example, incorrect implementation of EU directives in national law. Incorrect implementation of EU directives in national law. An example. Therefore, a member state may act in a certain way, and this action may be in conflict with EU law. Or secondly, lack of action. Lack of action. In Turkish, failure to act may also be in conflict with EU law. For instance, non-implementation of a directive. Non-implementation of a directive. It may not implement a directive at all. If the Court of Justice finds that there is an infringement of EU law, it shall specify the act or the omission that gave rise to a failure, but it will not tell to that member state what to do. It will only determine that there is an infringement of EU law because of the member state not acting or not acting properly according to European Union law. But it will not say to that member state what to do. Therefore, the member state, following the judgment of the Court of Justice, the member state must comply with that judgment. It may act according to the judgment of the Court of Justice. If it does not act, if it does not comply with the judgment of the court, then starts the second round of the enforcement actions, in which the member state may face with the possibility of financial sanctions. What is that in Turkish? Mali yaptırımlar. In the first round, have we mentioned any financial sanctions at all? No. The court will only determine that there is a breach of EU law and the member state should act properly according to this judgment. But if it does not comply with the judgment of the court, then there might be a second round of actions following this, with now the possibility of financial sanctions. Here, the Commission may take that member state before the Court of Justice. After it gives the opportunity to that member state to submit its observations. The Commission specifies a lump sum or a penalty payment. The European Commission specifies a lump sum or penalty payment. A lump sum payment or a penalty payment. A lump sum payment, any idea? It is a fine. Okay, a lump sum payment is a fine with a fixed amount. It is paid at once. All right? And a penalty payment is also a fine which is paid according to regular intervals, not at once, but at regular intervals until the breach is terminated. Okay. And if the Court of Justice finds that the member state has not complied with this judgment, it may decide on a lump sum or penalty payment. Why there is a second round in these actions? Why do you think there needs to be a second round this time? Yes, Deniz?
There needs to be deterrence against member states, because if there is not such a, if there wasn't such a deterrence in the EU system, then EU member states will not comply with the judgments and forever. Because there will be no sanctions.
There must be something against that member state.
Similar to United Nations system. I don't remember very completely, but there is a similar system in United Nations. In the first step there is a warning, and then at the end stage there is a sanction stage, for example.
But this is judicial, yes?
Just like Deniz said, they can't get away with doing something that is infringing the treaties. So if there is no second round, they can just do whatever they want, and there is no use or many meaning of the EU law, and it's not binding for them.
And when they infringe the decision of the Court of Justice,
Then the Court of Justice.
this means they infringe European Union law again. Huh? In the second round, the reason of taking a second round is that they have infringed a decision of the Court of Justice saying that you have to comply with this judgment. So the decisions of the Court of Justice are always binding on the member states that they have to comply. The Treaty of Lisbon added a provision to this one, which is provided under Article 260, paragraph 3.
Add the provision to first stage, second stage, or this?
I will explain now, okay? This provision is about transposing of directives. Transposing of directives. Transpose. You will be seeing when we speak about directives, sources of EU law. I will be telling you then that directives are not directly applicable. Meaning that when the European Union adopts a directive, for it to be implemented in the member states, they have to transpose it to the national law. Transform or transpose. Does this remind you a provision in Turkish law, just to make sure that you understand it better? Imagine that there is a directive on environment protection adopted by the European Union. I'm telling you that the national law, the member states, have to transform it to the national law before implementing it. No.
Article 19.
Transpose, transform. Transform? Exactly. Aktarmak. They have to transpose it into national law. İç hukuka aktarmak. Now, does this remind you something in Turkish law?
International agreements.
Exactly. Can we implement an international agreement to which Turkey is a party? In Turkish courts, for example, right away, right after signature? No. We need ratification, okay? It is similar to that. I will be explaining. EU directives also cannot be implemented as such, as a principle, right away. They have to be implemented, they can be implemented following their transposition into the national law. This is a very important characteristic, and we will also mention the only directly applicable EU instrument, meaning the only EU instrument which does not require such transformation is a regulation. Regulation? Tüzük. Meaning that once the EU adopts a regulation, its national law, once the EU adopts a regulation, a member state is under an obligation to implement it right away. It cannot, never ever, adopt an instrument to transform it into national law, right? You will be seeing why this is provided as such in the coming weeks. All right, therefore, Article 260, paragraph 3 is about member states which fail to transform directives into their national law. Here, when the action is taken against that member state, the Commission may specify a lump sum or a penalty payment according to this provision. And the court may decide at the end for the payment of a lump sum or penalty payment against that member state. The second possibility in the actions for infringement is provided under Article 259, where a member state finds that another member state is in breach of EU law. When you read the cases, you will be seeing that the first possibility will appear as European Commission versus Germany, for example. As far as the actions for infringement are concerned, European Commission versus Germany means European Commission here is the plaintiff or the claimant, okay? Versus meaning?
Defendant.
No, versus. Exactly. Against Germany. Germany is the defendant. So, what would that mean? If you read a case like that, an action for infringement, what would that mean? When you just see the name of the case, you will understand that.
Germany is in breach of...
Or the European Commission thought that Germany is in breach of EU law, so it took an action before the Court of Justice under Article 258. All right? This means this is the first possibility, that the European Commission considered that Germany was in breach of EU law. What would you think if you see France versus Germany, for example? Yes, this is the second possibility. Now we will be speaking. France thought that Germany was in breach of EU law, therefore took it before the Court of Justice. All right? Under 259, when a member state considered that another member state has failed to fulfill its obligations under the treaties, first, it shall bring the matter before the Commission. Therefore, it does not go before the court right away, but it goes to the European Commission. The European Commission has a 3-month period here to deliver a reasoned opinion. If the European Commission does not deliver an opinion, a reasoned opinion, within a 3-month period, then that member state may take the other member state before the Court of Justice. As I have mentioned, at the end of the actions for infringement, the court shall determine the infringement only, either by prohibiting the member state to act in a certain way or obliging the member state to act in a certain way. And at the end of the actions for infringement, the ruling of the Court of Justice may either prohibit the member state concerned, in Turkish, the member state concerned, söz konusu, prohibit the member state concerned to act in a certain way, or may oblige the member state to act in a certain way. Therefore, the actions for infringement may either be about a member state acting in a certain way, or may be about a member state by not acting in a certain way. But both of this, both an action and an inaction, must infringe the obligations of that member state arising from European Union law. Okay? And as we stated, the European Commission has the sole power to act in the actions for infringement. First, to start this procedure by administrative stage, and then taking the member state concerned before the Court of Justice, but it exercises a full discretion to take that member state before the court or not. All right? When we speak about infringement actions or enforcement actions, you should remember that these are against the member states only. Okay? Then we will move to actions for annulment. In Turkish, yes?
I was going to answer.
Sorry?
I was going to ask a question, not answer.
Okay.
Okay, can institution have also acts of infringements as well?
Wait. No. If you call an action for infringement, it is always against the member states. It is always taken by the Commission or another member state. This is also the principle of limited powers. This is also the principle of limited jurisdiction. The powers of every institution is provided in the treaties, and they have to act according to the treaties. This power to take an action for infringement is only provided for the European Commission against member states. Therefore, can, for instance, the European Parliament take this action before the Court of Justice?
No.
Not possible. Why not?
Because the European Commission has the sole power.
Yes, but why not? It is not because the European Commission has the power, but
They don't have it.
the European Parliament does not have it. How do we know? The treaty does not provide such a power for the European Commission. Can we say that the European Commission may take an action for infringement with this name against the European Parliament? No, because the defendant is not the European Parliament for the action for infringement in EU law. There will be an action, there can be an action against the European Parliament, or the European Parliament may take certain actions before the European Court of Justice, but they are not called as actions for infringement, okay? As an answer to your question and to finish it for today, when there is a breach by an institution of the EU,
It's called breach.
sorry?
Is it called breach when it's by the institutions?
No, infringement or breach, it is the same thing. The action may take two forms. It is either an action for annulment or an action for failure to act. When it is a member state which is in breach of EU law, the name of the action is infringement. When it is an EU institution which is in breach of EU law, well, it depends. If the institution breaches EU law by acting, that is annulment. In Turkish, iptal, because there is an act, as you will be seeing on Friday. When an EU institution breaches EU law by not acting, that is failure to act. An action for failure to act, an action for annulment. All right? Therefore, it is important who is the defendant of that action, a member state or an EU institution. Yes, Öykü.
I didn't get what you said for Article 260 about the directives. I didn't get the part where they get a lump sum payment or...
When Commission is taking an action against a member state for not transposing a directive, it may specify a lump sum or penalty payment. There was no such provision before the Treaty of Lisbon in the founding treaties. The only provisions that existed then was 258, 259, but there was no specific provision on transposition of directives in EU law. This is new, that when Commission brings an action, it may also specify a lump sum or penalty payment.
So not transposing the directive is also a kind of action of infringement?
Exactly. 260 also provides for actions for infringement. All right, these three provisions is about infringement actions only. All right, any other questions? Thank you very much then. I will see you on Friday.